Hey folks, and we're back. So, History of Retirement, Part 4. Just going to start with a quick overview again. We have covered war pensions, Rome, and the Revolution, and World War I. We've done private pensions, and now it is time to discuss, in Part 4, ERISA. Then after this, we'll go on to the final part, Part 5, and discuss modern defined contribution pension plans. So to review, our key issues, right? At this point, you should be used to them: purpose, administration, vesting, funding, and fairness. We're going to see all of these again, and we've seen them through all of the historical case studies and examples. So I think at this point, you should understand that retirement covers a lot of these issues, and ERISA is trying to address all of them in one way or another. So ERISA really is not so intimidating. Finally, on to ERISA. So it was passed in 1974. It already had a lot of the rules in place in one form or another, so it built on and expanded a lot of existing rules about vesting and reporting, disclosure, but it increased a lot of those rules. It added new ones. It added this new reinsurance through the Pension Benefit Guarantee Corporation. And pension insurance was a big change that did not exist in previous versions of regulation of pension plans. ERISA was also enforced by the Department of Labor and by the Treasury, which is the IRS. And then the PBGC has its role to play as well. So here is a picture of President Ford signing ERISA. And here in the background is Senator Javits. He was the primary sponsor of ERISA, although you'll notice he's not even clearly up front for the photo signing it. He's actually a very interesting guy. He's probably, if not then one of the most liberal Republican senators of the 20th century. Interesting guy. He voted for Vietnam, but by a couple years later, he was already calling for a peaceful resolution. And then by 1973, he sponsored the War Powers Act. So a very, very important lawmaker just for those two laws, ERISA and the War Powers Act, which tries to rein in the president's power over foreign policy, and then ERISA, really still a very important law regulating employee benefits, retirement, health and welfare, things like that. So a lot of impact. And of course, if you live in Manhattan, you might just know him for the Javits Center. But he very, very interesting guy. He actually lost the Republican primary in 1980, but he was still endorsed by the New York Liberal Party through the weird fusion law they have in New York. Then he lost re-election anyway, even though he was still on the ballot. And but just a very unique, unusual guy, and he was really the driving force behind ERISA. He kept pushing it for years and years. Both companies and unions were really fighting, but eventually he got enough momentum to get it passed, and a very, very unusual character in politics. So the basic rules and standards of ERISA, and after it, we've got the fiduciary duties for how you have to act in the interest of participants. There are a lot of funding rules, communication and disclosure rules, a lot of reporting about benefits or assets to the Department of Labor and to the IRS. There are certain requirements about the benefits you have to offer, like survivor benefits or spousal benefits. There are rules about minimum eligibility vesting standards rules. There is, of course, still the non-discrimination for highly compensated employees that continues to show up in ERISA, including the tax code. and rules about ERISA plan assets and fiduciary standards against self-dealing or using the assets for your benefit and not for the participant's benefit. So this is just the basic structure of the law, and you can see that it's actually relatively straightforward. It's just these four titles. Title 1 is the DOL. It's new benefit rules, all the disclosure and the vesting and the funding, all of the things that the DOL is going to enforce are there. And then Title 2 is all of the tax rules. A lot of these tax rules are exactly the same language as a lot of the DOL rules. So it really is meant to be jointly enforced by them in a lot of different ways. And then some extra rules are in the tax code and some unique rules are in the DOL section. But you can sort of see how it's shaping out if I just show you these four titles. Title 3 is really behind the scenes. It's just between all the government agencies and how they're going to work that out. And then Title 4 is the pension insurance, the PBGC. So if you can see just these elements, it's really not very complex, even when you get into this part, which is maybe the most boring part of the entire series. It's still relatively straightforward. You can sort of see what's going on, even if you don't understand the specifics. So I'm not going to dive into the whole law, but just at a high level, this is the sort of stuff that's in there. This is just looking at Title 1, which is the Department of Labor stuff. You can see there's stuff on reporting and disclosure. So that links back to our key issue of administration, right? And part 2 is participation in vesting. Well, that obviously vesting links to our key issue of vesting, but participation really links back to fairness. We've got an entire part 3 called funding, which you can tell what key issue that links to. Part 4 is the fiduciary responsibility, so that really comes back to the purpose. The purpose is to serve the interests of participants. So all of our key issues are right there. You can see where they're coming out. And then we have a few other parts that are in Title 1, like how it's enforced in Part 5. And then Part 6 and Part 7 are COBRA and a lot of health plan requirements that come out in very specifically in the health plan context. So we won't get into that and you don't need to know it, but if you remember all of the key issues that we saw throughout history, you can see this is why ERISA exists. It's very straightforward and it doesn't need to be intimidating. So what does, just at a very simple basic level, what does the DOL do to enforce ERISA? Well, they have the responsibility to monitor for fiduciary issues and benefit protections. So that's things such as investment selection for plan assets. That's late contributions of plan assets to the trust. That's prohibited transactions where you're using assets of the plan in a way that is improper or not allowed. That is the failure to provide some of those required disclosures and communications and other notices that you have to provide to participants. There are the health plan and what are called Part 7 requirements. Those are very particular to health plans, but the DOL has responsibility for monitoring them as well. Overall, the DOL is not really trying to enforce penalties. They're trying to force plans to follow these rules, and in some cases, they will force restitution with interest or earnings of participants who've been wronged. But they're really not trying to raise money. They're not trying to raise revenue for the government. This is not the IRS. They don't have a tax mission. They have a compliance mission. They are trying to make sure that all of these rules are obeyed and that employer plans and union plans are treating their participants fairly and consistently with ERISA. So the section of the DOL, the agency within the DOL that enforces it, has gone through a couple of different names. It's called EBSA now, the Employee Benefit Security Administration, but it's had some other names in the past. It's sort of like the subsection of the DOL that is dealing just with employee benefits. So they get very specialized. And they really know what they're doing, and it gets even further specialized within that. For all the different types of issues the DOL sees, they have experts. So what does the IRS do? Obviously, we all know they collect your taxes, they pay you a refund if you are due one, they send you angry letters sometimes saying that you owe them money. They audit you. Many of us understand that, although many of us are never going to be audited. We understand that that's out there. But what do they do in the plan benefit context? What are they doing for retirement or health plans? For retirement plans, they are monitoring for technical compliance for what's called tax qualification. So if you qualify for all those tax benefits that have been in the tax code for essentially a century in some cases, the IRS needs to make sure that the plan is appropriately receiving those benefits, that it is qualified to receive all of those tax conditions, all of the various deductions, all of the exclusions. The value of the tax qualification is enormous. It lets the employees defer income, it lets the employer deduct. I could go on and on about why this is really special and valuable in the tax code and why there are relatively few opportunities where the employee gets to defer income and the employer gets to deduct it anyway. But let's just settle with it's very valuable, and the IRS needs to monitor that your plan is appropriately getting that value, that you don't have a substandard plan that's getting the value and doesn't deserve it. They are also enforcing maximum benefits. They are enforcing non-discrimination. If you violate those rules, the IRS can come in and require you to levy extra tax, basically to report or withhold extra tax on employees. So there's really some teeth to that. It's not just you need to follow the rules. It is follow the rules, or the employer and the employee could both pay extra taxes, which is especially valuable when you're dealing with highly compensated employees who often have a lot of pull within an employer organization. The IRS also handles a lot of proper reporting and correct withholding. So for the income tax, that's really important. Retirement plans need to be able to do that. The IRS is very big on plan formalities and plan failures, and they have an entire process for you to report your plan failures. They have a lot of rules about following the formalities of a written plan, similar to the DOL, which has their requirements for communication and disclosure. The IRS has other plan formalities that they are looking for, like that the plan is properly written and that the written document is being updated at the right time. And that includes timely adopting plan amendments if there are changes in the law. The IRS will also levy excise taxes as penalties for noncompliance, especially for prohibited transactions, violations of those fiduciary rules. There are also rules about funding under ERISA, so you can't have the situation like Studebaker where there just is no money in the trust. If you have a trust with a promised benefit, there is a minimum funding standard for an ERISA plan. The IRS will enforce that, and they can enforce that annual funding rule with penalty excises for underfunding. So there's a lot of teeth there. And let's go to PBGC Title IV. This is really in some ways the most unique part of ERISA. The DOL obviously has lots of rules, lots of different roles that it plays in regulating employers, and the IRS has its function to raise revenue and perform other tasks for the government. But the Pension Benefit Guaranty Corporation is really just doing this one thing. It just exists to reinsure pensions against the risk of insolvency. So they are squarely within ERISA. They did not exist before ERISA. They wouldn't exist without ERISA or something like ERISA in the future. That this is central to their mission, is just ERISA. If a plan does not have enough money to pay benefits, the PBGC is on the case. They also do some preemptive monitoring of financial risks. They can assist certain plans. The best way to think of them is like a quasi-public corporation. And there are many, many, many examples of quasi-public corporations in the United States, but probably the FDIC is the best example, the Federal Deposit Insurance Corporation, because they are insuring your deposits with a bank. The PBGC is insuring your vested benefits with a pension plan. The PBGC gets its money from premiums, which are paid by pension plans, from bankruptcies of covered pension plans, from the plan assets of plans that the PBGC has to take over, and from investments on 1, 2, and 3. It can invest those assets and then spend that on its mission. But otherwise, it's not supposed to take money from the federal revenue. It's supposed to be independently funded. The idea is that the premiums ought to be supporting it, although, as we'll see later, they don't actually support it. The premiums are not high enough. So the premiums are set by law. Last year, 2019, the rate was $80 per participant and an additional $43 for every $1,000 of unfunded vested benefits, up to a max of $541 per participant. So that has actually been a so-so funding level for now. The PBGC is not too bad with that number, except that you can see multi-employer plans, it's only $29 per person, and they do not pay anything for their unfunded amount. So that means, as you can guess, that the multi-employer plans are drastically over cost. They cost way more to insure than the premiums. They are not covered by the premiums at all. The two programs are actually separate, so the PBGC multi-employer program is separate from the single employer program. And multi-employer is almost exclusively union plans where the union is running the fund, and the pension plan works for union workers who might work at multiple different employers, or each worker might work at only one, but they have still a pooled together union pension plan. The PBGC insurance for those is awful. They just don't have enough money. And because those plans have been underfunded for so long, they keep asking the Congress to please give them PBGC relief. Basically, let them not pay premiums commensurate with the risk that it would take to insure them. So even though the unions were very big on pension reinsurance when Studebaker happened and when other mid-20th century large pension bankruptcies happened, ultimately a lot of unions have also been pushing for relief to not pay premiums for the PBGC to actually insure them. And this has been going on for such a long time that it's a huge problem. There is a huge problem. So we will talk about that in part 5 on the current trends. But as you can see, that is not matched at all. That does not match their risk. The PBGC will generally take over for certain bankrupt plans and start paying its benefits. But if the plan assets are low, it will reduce the benefits, and then it'll reduce them down to a statutory minimum that the PBGC has to pay as long as it has money, but that statutory minimum is also just very low. So generally, it's called reinsurance, but they do not reinsure the full amount. If the plan assets are low, they can cut your benefits. So the reinsurance is actually not of significant value. It's more of a backstop. It is not meant to make sure nothing happens. It's meant to just stave off the worst. And here we are back at our key issues: purpose, administration, vesting, funding, and fairness. Now that we've seen them over and over again throughout history, we've seen how ERISA works, we can really see how they link together and why it is that ERISA is doing all the different things that it's trying to do. And I've tried to break it down here, but you can see the key issue of purpose. ERISA has fiduciary rules requiring that plans operate just in the interest of participants, and certain transactions are prohibited when they are not likely to be solely in the interest of participants. And you might need to get special exceptions in order to have those transactions because there's a high risk of violating the trust of the participants. And that's because the reason these plans exist is to serve participants, and that's what ERISA is trying to achieve. The administration key issue, there are a lot of disclosure rules in ERISA. Both the DOL and the IRS have their hand in enforcing various parts of those rules, but ultimately a plan is responsible for explaining and distributing benefits. That means a lot of rules about how plans communicate with participants, what they have to explain, how often they have to send you information. etc. And ERISA is really trying to achieve that, just to simplify the administration so that you know what you can claim and how to claim those benefits. The vesting rules are actually rather significant. They're incredibly dry in the details, but overall, it's very basic. I think we can all understand it intuitively. ERISA tries to guarantee that if your benefit is promised, it is actually promised. There can't be too long a time where it stays tentative. You have to have certainty. So you couldn't go 20 plus years, 30 years, where an ERISA plan says you have this benefit, but it's unvested, and you might get confused and not understand what unvested means. You might think that you had a promise, but you didn't. ERISA tries to eliminate or reduce those situations, tries to give all sorts of other rules that stop plans from taking away your benefits. So that there's a lot in there, but ultimately they are just trying to make sure that if you have been promised benefits, you're going to get them, and the plan can't take them away from you. Funding is very similar, of course. There are lots of funding rules. Both the IRS and the PBGC and the DOL, to a lesser extent, will enforce the annual funding rules. The IRS will even charge excise taxes. The PBGC will charge higher premiums on a single employer plan for underfunding. So there are a lot of different rules trying to make sure that the Studebaker thing never happens again. We don't have a situation where a trust is making generous promises, employees are moving to a company on the basis of these generous pension promises, and then they find that the cupboard is bare, the trust does not have enough money to cover all of these generous promises. That it just can't happen under ERISA, or at least it's designed not to be able to happen. And then, of course, you have the PBGC there to reinsure it as a backstop. And our fairness key issue, we've talked about the non-discrimination rules, but there are just a lot of rules shot throughout ERISA that are trying to make sure that overall a system is fair. It sort of comports with what we would expect it to do. It treats people fairly. There are lots of benefits in there to make sure that you know how to become eligible. It's easy to achieve eligibility. That's just all throughout, little bits and pieces, trying to make sure that it is as we would expect it to be, and that a plan is not being too harsh. So it's really a lot of different pieces, and they're all moving around, and it's very easy for even an expert to think that ERISA is very difficult, that it's overwhelming, that it's very dry, and why would anyone be interested? But it's really just these basic issues. We're trying to look out for people. Why do we have this plan? Where are we acting consistent with our purpose? And how do these people claim benefits? And how do they enforce them? And how do we fund them? And are they fair? It's very basic rules, and I think hopefully you can see that now that we have gone through ERISA. So we do have what are called non-ERISA plans. There are a number of different exceptions. I've highlighted 4 of them. Governmental plans are generally not covered by ERISA, and this is state and local. Federal, of course, is also exempt, but generally it becomes an issue with state and local, many of which will have, at least on paper, sizable unfunded liabilities. But they are, of course, backstopped by their tax power. So that is a historical artifact where the idea was that the state should monitor themselves. The state should be able to look out for their own employees and make sure that they're being fair. And in practice, the states and localities have not managed this trust very well. They have not behaved very appropriately, and probably it would have been a lot better if ERISA had extended at least some protections, such as funding, to the participants in governmental plans, but that is not the case. So that is perhaps the most significant type of non-ERISA plan. We've also got church plans. There is just generally a special exception for churches, the idea being that they're nonprofit, but more than just nonprofit, they often don't have enough resources or sophistication to deal with this. That was sort of the argument at the time. Church plans are still, of course, governed by the tax code, but then the tax code has special church rules that are often quite lenient. In practice, a lot of the church plans try most of the time to follow ERISA standards just because so many people expect them on an intuitive level. They think that the benefits you get in an ERISA plan make sense, so when people go to a non-ERISA plan, they often expect a lot of the same standards. So many church plans will try to hew closely to ERISA rules, except where the cost is more significant. There are also what are called top hat plans or executive compensation plans or non-qualified plans. They go by many different names, but top hat plans are essentially plans just for the bigwigs, for the executives. The idea is that employers want to give the executives more money, and that's fine, but those executives don't need extra protections. They don't need special favors. But in order to take advantage of the top hat exception, it has to be a relatively small, defined group of executives and highly compensated employees. It can't be half the company, right? It needs to be a small, select group to really say, you guys know what you're doing, you are at the top of the company, you have the most influence, you have the most leverage in negotiating, you need to look out for yourselves. But we don't want this to mix with the general employee population. So ERISA tries to protect the general employee population, but non-discrimination does not apply to top hat plans. And at the same time, top hat plans are not as advantageous in the tax code as regular qualified ERISA plans. Although there can be tax deferral, it's just not as expansive, it's not as valuable as a regular ERISA qualified plan. And then you have also retiree-only plans. They are non-ERISA. If you have no employees because everyone is a retiree, then ERISA does not apply. So because ERISA focuses on employees, it does not usually play a direct role. The tax code will still be involved. State law will end up mattering a lot. Retiree-only plans are often seen with union employment. And for the last few decades, employers have really been trying to avoid these plans, especially when they offer health care, lifetime free health care that can be incredibly expensive. So, but you still see a lot of these, and they can take a lot of different forms. And some of them will be ERISA because they mix employees and retirees, but others will be retiree only, and that allows you to get out of ERISA. So I've just explained our key purposes, our key issues again, with the non-ERISA plans. You can sort of see some of the value of ERISA is sidestepped or missing with some of these non-ERISA plans. The vesting is especially significant because non-ERISA governmental plans can have much longer vesting than ERISA, a 15-year cliff or 20-year graded, and there's an even longer exception for public safety employees, and church plans can also have long vesting, and top hat plans, it often doesn't even apply. It's almost always vested already, but you have a bankruptcy risk because you often won't have a dedicated trust. So it's actually, in many cases, riskier to have a top hat plan. It's worse. It seems like the executives would get the best, but this is a worse form. It's just that if you're getting paid so much money, you need to get some kind of tax benefit. It's not as good as an ERISA qualified plan, but they need something to try and defer tax, so they're willing to accept this worse version of a plan that offers fewer protections for them. The funding is also very up and down. Church plan could just be a trust. It could be just like any regular ERISA qualified plan, but public plans can be also very up and down. They could be tax funded and put into a trust, but that's not mandatory. Ultimately, because they're backstopped by taxes, public plans generally are very secure for the participants. They are not secure for the taxpayers, of course, or for the budget of the state or locality that has them. Usually the participants are mostly secure because of that promise. Usually under state law, the promise will be vested. But it can result in a significant political problem because other priorities like spending or tax levels could be significantly altered or crowded out just to pay for the vested unfunded promises. But really, what's interesting with all of these is the fairness, right? We're expecting Congress is expecting public plans to be monitored by the governments themselves, and that's sometimes the case, but not always the case that they're doing a good job of that. Church plans are essentially getting a special deal because they're nonprofit and they're very low income, and they often just have a very special situation, and they're considered very sensitive. So it would be unfair to push them into burdensome regulation. At least that's the understanding of Congress when it put these rules into the tax code, and when it passed ERISA, that they wanted to make sure churches were not unduly burdened. Whereas Top Hat, the fairness rationale is the opposite. Executives gotta look out for themselves. We don't care. We're not protecting you as long as it's just a select group of management and highly compensated people. You're on your own, folks. So it's a very different reason. And then retiree only plans, it's not that retirees don't need help and that they don't need protection, it's just that you're not employees. And to some extent, if the ERISA regulation is too harsh on retiree only plans, maybe there won't be as many retiree only benefits. So if we keep the regulations not as harsh, maybe there will be more of them. It's also outside, to some extent, the Department of Labor purview generally. So a lot of interesting issues, and I think the non-ERISA plans help explain some of the contours of ERISA itself. So that's it on ERISA and the history that led up to it. But what has happened since? Where are we now with the shift from these defined benefit pension plans and now defined contribution plans such as 401k? Well, that'll be in the next part, the final part 5. All right, hope to see you then. Thanks again.